paragraph 29A, here we are right here. A single business day is defined as a 24-hour period that begins at 8 a.m. on a weekday, Monday through Friday. It's important to understand business days do not begin or end on weekend days, Saturdays, Sundays, or any federal legal holiday. And to find the federal legal holidays, all you have to do is type in federal legal holidays 2020, and about 15 federal websites will come up and tell you what they are. All right. For purposes of this contract, the first business day does not begin the day we ratify the contract, but it begins at 8 a.m. the business day following contract acceptance. Now, Matt and I did, I think with you, John, a fantastic video that is in the archive for CCRA that y'all should go to and watch a video on. We did probably 7 different examples of when the contract was ratified, like on a holiday weekend, on a weekend, early in the morning, and showed you how the dates are counted. So if you're interested in that and counting and understanding that, go watch the video, because we could spend half an hour on this, and I don't really have the time to do that because we're already an hour and 15 in. It's also important to understand business days begin at 8 a.m. So essentially they begin at 8 a.m. They essentially end at 7:59 the next day, next business day. And that's important to understand these time frames when we do 9 and 10. So under paragraph 10, we have a couple of things we need to talk about with as-is properties. Paragraph 10 is when your client wants to buy the property as is. 10B is what we're going to start with first. This is property is being sold as is, no due diligence period. This is the person is willing to buy the house in its current state. They're not going to do any inspections. They're not going to ask for any repairs. They're just going to buy it as is. A lot of times what this may be is a tear down situation. There's an old shack up on Lake Murray, and this person's got plans to build this $1 million house up there. They don't care about this house because the day they sign the contract and they close, bulldozers are going to be on the site. So they don't need to do an inspection of your house. They don't need to do anything. They're just going to tear it down. This also could be used as a very strong offer if, for instance, you bought a house on, let's say Executive Construction built your house. You bought it January 1st. Here we are in August, and I get relocated to Tennessee. If somebody wants to buy my house, they know it's still under warranty, under the first-year builder warranty, and they also know that Executive Construction builds excellent houses, so maybe they don't need to do any due diligence, because if there is an issue in that first year, they can just go to Executive Construction under that warranty and say, hey, first-year warranty, here's the punch list items. So that's something you might be able to use as a strong offer in a competitive market. 10A is a little bit different. This is, we're buying your house as is, but we are not going to ask for any repairs, even though we are going to do inspections. Basically, your house looks like a hellhole. I just want to make sure that it's not a money pit and a hellhole. And so I'm going to do the inspections. I just want to make sure how bad it is. This was used a lot back in the day. I had a couple of investors who would buy houses in Rosewood and Shandon that almost were on the verge of needing to be torn down, and they would go in and gut the house. They wanted to do inspections so that they could see what they were going to be looking at when they had, what they were going to have to do. Were they going to have to replace the roof? Were they going to have to replace the air conditioner? Were they going to have to rip out plumbing and wiring? So they wanted to do the inspections, but they weren't asking for repairs because most of the time they were making kind of lowball offers anyway because the houses were in poor condition. I have seen this paragraph abused. Matt and I did a fantastic video. It's on my web. It's on our YouTube page. If you go to YouTube and type in Blair Cato, we did a series called Brokers and Cars Talking Contracts. It was loosely based on Jerry Seinfeld's Comedians in Cars, or Comedians in Cars Getting Coffee, or whatever that was. And we talked about these paragraphs in a 2-part series. It was about 40 minutes. And we talked about this in that video about how these are being abused. The intent is that your client, the buyer, does the inspections, and either they decide they want to buy it or they don't based on what they find. There's no intent for the buyer to actually ask for repairs. And there's nowhere in here does it say buyers to ask for repairs. In fact, it says they won't. So when the buyer asks for repairs, essentially at that point, contract's void. At that point, the seller can move on. Because what the seller's saying is, the buyer's saying is, I'm not going to buy it unless you make these repairs. Well, you basically exercised your due diligence provision by saying you're going to buy the property. And so what happens, unfortunately, is the buyer will say, I'm not buying the property unless you do the following repairs. And the seller's like, well, you're under a due diligence, sold as is. And they're like, okay, well, I just won't buy the property. And the seller goes, okay, I'll make the repairs. That unfortunately happens. Now, in today's market, as competitive as the market is right now, buyer trying that, good luck. There's probably another offer out there they can jump on. So I'm not sure that's a good option. So that's how paragraph 10 works. Now, let's go back to paragraph 9 because this is important. Paragraph 9 is how most of us buy and sell property in our market. Paragraph 9A says that the buyer has 10 business day due diligence period to do any inspections, whatever they want to do at their expense. Keep in mind, it's 10 days once the contract's ratified. So if I sign a contract here at 10 a.m. today, my period does not start until tomorrow, because tomorrow, we don't count today under our business day definition. We'd start tomorrow on the 13th, and we count 10 business days. It does not include weekends, does not include holidays, can't begin or end on a Saturday, Sunday, or holiday. So 10 business days in reality is typically 13 to 15 days. Now, as a side note, I will tell you, I have had this happen a lot recently, that agents will say, the house will fall through, the transaction DTFs, it defaults, or it doesn't close due to due diligence. And the title work's already done, and the agents are like, well, why did you order title work? You should have waited until due diligence. I don't know a single lawyer who can wait till the due diligence is over to order title work, because remember, if your contract's a 30-day or a 45-day close, just to get through buyer's due diligence is typically 14 to 15 calendar days. That's almost half of the closing period. Your lender wants title work typically early as possible. And so as we go through the rest of this provision, you'll see it's impossible to wait for due diligence period to be ended before you order title work unless you're doing a 60-day close. It won't work. So you need to tell your client the title work is basically like doing inspections. They have to understand that's the risk they're going to take. Now, the buyer can do any inspection they want to whatsoever, including HVAC, and it gives you a list, termites, and things of that nature. If there's a certain provision, a certain section, or a certain item they cannot inspect because inspectors aren't available, or it's a very specific type of matter, then the parties can agree that the due diligence period will end to everything else, but that period will be extended for that particular item. So for instance, let's say my home inspector comes out and finds something that a specialist needs to come out, something maybe like radon gas. I don't know how hard it is to find a radon gas expert, but they're suggesting that the house be looked at for radon gas and see if there's an issue with it. And maybe the only radon gas expert in Columbia is booked up for 3 or 4 more weeks. That is something the parties can agree to extend, finish due diligence to everything except the radon gas. Now, during this due diligence period, the buyer has a couple of options. The first option is during my due diligence period, I can say, I accept the property, I finished my due diligence, I'm good to go. The second thing they can do is in the sole discretion of the buyer, or, and there's a key word, or as a result of any inspection, examination, or test conducted. So it's not saying buyer as a result of an bad inspection or a bad examination or a test. It says buyer has 2 ways to cancel. In his sole discretion, which means he don't want to buy it anymore, or as a result of any inspection, examination, or test. If that buyer determines the property to be unsatisfactory, the buyer may terminate the contract. And in order to terminate the contract, they have to provide entire copies of all inspection reports and give you written notice. Why did we put entire inspection reports? Because the seller has a duty under seller disclosure to update the seller disclosure form when they learn that there's anything that's misleading, incomplete, or inaccurate. Well, if your buyer did an inspection and found out that all the windows in the house are completely rotted and need to be replaced, the seller needs to be informed that through the inspection report so that they can update the seller disclosure, because they have an absolute duty under the law to either repair it or update it. And so that's why you have to have the inspections. You cannot cancel without providing the inspections. This does not mean, as agents have tried to argue before, that, well, because it requires you to provide inspection of copies reports, it therefore means you have to do inspections. It doesn't say that anywhere. And remember, a buyer can cancel either because of inspections or in his sole discretion. So there doesn't have to be a single inspection. Now, why did we give the buyer 10 days to change their mind and just say, I don't want to buy it? Because back prior to 2016, or 2006 rather, we were writing this contract, 2006, 2008. If a buyer didn't want to buy the property, they would wait till the week of closing, and then they would just come up with some convoluted reason they didn't want to buy the property, and it created all kind of chaos because the seller's closing would fall through then. Their purchase that the seller was going to buy would fall through, and it'd be a domino effect that 3 or 4 closings may fall through. And so we would rather have a buyer have buyer's remorse and cancel within the first 10 to 15 days of signing the contract than we would the last 5 or 10 days of the contract, which is what was happening prior to 2006, 2008. Once we put this provision in there that the buyer basically can cancel because they get buyer's remorse essentially, or they don't like the way the inspections look, I think it's eliminated a lot of that problem. Now, we still have buyers that some reason will still think they can just cancel the day of closing, but I think it's done a lot to eliminate that. So first option is buyer can accept property. Second option is in their sole discretion or as a result of an inspection, they can terminate the contract by providing inspection reports and written notice that they are terminating. Now, if the buyer fails to provide notice during the due diligence period, then they will be deemed to have accepted the property as is, and seller has no obligation to make repairs, and we're moving on. So really, that's another thing a buyer can do. A buyer can just say nothing, which means he's buying the property in the condition it's in. He can verbally or affirmatively say, I accept it and we're moving forward, or he can terminate the contract. That brings us to our last option. Under paragraph 9C3, buyer can request repairs or replacements to the property, and when he does so, he must submit complete copies of inspection reports signed by the buyer, identifying, and the addendum signed by the buyer, identifying specific defects they want corrected. So you have to provide a repair addendum that's specific as to what you want done. And this is another problem we see in the industry. I've seen people just put in there in the repair addendum items number 1, 4, 6, and 7 on inspection report. Okay, what do you mean? You want us to look at it? You want us to repair it? What is it? People aren't doing the who, where, why, who, when, where, why, and how. What you were taught in elementary school. Write a paragraph like you did in elementary school. Who's making the repairs? When's the repair going to be made? How's it going to be made? Who's going to pay for it? What time frames are going to be done in? Things of that nature. Who, when, what, where, why, and how. Be sure to put all of those things in there so that they are covered, because we're not seeing that. Now, a question we get all of the time is, what happens if I submit a repair request on day 1? Does that mean I'm done with my due diligence? The answer to that is no. If you submit a repair request on day 1 and the seller agrees to it, unless there's specific language in that repair addendum saying that it hereby ends the due diligence period, that doesn't end anything. The buyer can then continue to do other due diligence. And the reason that is if I am the buyer and on my very first inspection, I do a CL 100, and there comes out in the CL 100 that the house needs $20-something thousand worth of seal work because the seals are rotten in the house. Before I waste my time doing a heating and air inspection, I need to know whether you're going to spend $20,000 to make those repairs. And if you're going to come back on the CL 100 and say, no, I'm not going to make those repairs, then I'm going to terminate the contract. I don't need to do any other inspections. So when I come out and say, I want this done, and you say, okay, I'll make those repairs now, okay, he's going to make that. Now I'll go ahead and complete the rest of my inspections. So if you are a seller, you can either agree to the inspection now and understand that, or agree to the repair addendum and understand that there could be more requests coming your way before the 10-day due diligence period ends. Or you could respond back to the buyer and say, I've received your repair request. I will either wait till my time to respond, or I can respond now, ending the due diligence period. Which would you prefer? And the buyer could say, yeah, go ahead and respond now and end it. And then you would respond, yes, I'll make the repairs if you want to, and then put this hereby ends the due diligence period. So that's how you need to handle that. Don't just assume because somebody gave you a repair request on day 1 that it hereby ends the extension, the period. It does not. All right. Again, if you fail to provide or request repairs, you're deemed to have accepted it. That's kind of repetitive. Once the repair addendum has been submitted, the seller has 5 business days, and this is very important, from the expiration of the due diligence period to negotiate the defects to be corrected by the seller at seller's expense. Buyer has 10 days, business days, to do the due diligence. When that period ends, that begins the period for the seller in order for them to determine whether or not they're going to make the repairs requested. 5 business days. So right now we're already at 15 business days, right? 10 days for the buyer, 5 days for the seller. So 15 business days is more likely 20 to 22 calendar days. So again, now you can see on a 30-day close how it's impossible to wait till your inspection period's over to request title. It doesn't work. Now you'd be down to 8 days. Can't get title work in Columbia right now in 8 days. Ain't happening. All right.
Hey, Gary, can I make a point here real quick?
Absolutely.
This 5 business day period, what's highlighted is that the seller has the 5 business days. But what's important for everybody to realize is the buyer and seller have the 5 business days to negotiate the defects. So it might take the seller 5 days to get their quotes and everything, but there still needs to be time to negotiate it out. So
right.
Hopefully the parties would then extend it, but it's not just the seller's time, it's the negotiation time.
Right, but the seller can literally, one thing, she's correct, but the seller could wait their 5 business days to even respond to you. Now, the seller does that at a risk. If you, during your due diligence period, you send me a repair addendum and I sit on it for 5 days. I don't respond to it because I got 5 days in which to do something to it, and I don't respond to you for 5 days. You could rescind your contract offer and move on to something else. So I could lose you as a buyer. So it's not very smart for the seller just to ignore the risk. And so the seller needs to understand that during that period, like Becky said, buyer's time too. And so if buyer decides they want to walk during that period because seller hasn't responded to them quick enough and they decide they want to buy the house, that can happen. That actually happened. I had a broker last week call me about it. So it can happen. Now, the seller can do certain things. They can agree to make the repairs. They can refuse to make the repairs. They can just not even respond, which if they don't respond during the 5 business day period, it means it's the same thing as them saying they're not going to make the repairs. Or they can submit a counteroffer for repairs. And that's the options that the seller has to do. If the buyers and sellers have not reached an agreement during this negotiation period that Becky correctly said is a 5-day business period for them to negotiate, the parties may extend the period to negotiate, or the buyer will have 2 days after the end of the negotiation period to either accept the property as is with no repairs being made, or they cancel the contract. So the reason this provision here is super important, in my opinion, one of the most important provisions we added was back in the day, buyers were scared to ask for repairs because if they asked for a repair and the seller said no, we had nothing. The contract was done. So we had put a provision in here that if I go to Becky and say, Becky, I want you to make these 6 repairs, and she goes, I'm not making any of them. Buy it or don't buy it. I don't care. I now have 2 business days to say, okay, I'm going to buy it. I still want to buy it. So there's no risk in me asking for repairs. I do have the right to ask for repairs. If Becky refuses to make them, then I still have the right to buy the property. And we wanted people to do that. We didn't want people to be scared to ask for repairs. All right, if the negotiating period is not extended, the buyer does not accept the property as is within the time frame, either party can terminate. The reality of it is, again, if we've done the 10-day due diligence and we've been negotiating during the 5 business days, and my 2 days as the buyer has expired for me to say, okay, I'll just buy it anyway without you making repairs. Once we're past that period, we don't have anything. I mean, essentially, it's just you're trying to keep it together, but there's really not a contract at that point because nobody's agreeing to anything. But we did put this provision in here to try to keep people negotiating to hopefully try to keep it together. All right. The other thing in inspections before we move on, FHA and VA appraisal inspections. Some of our inspections for VA take a little bit longer, and so if they can't be done within the due diligence period, and that appraiser identifies things that have to be made, repairs that have to be made as a condition for the loan. If the seller elects not to do them, the buyer then has the option of either paying for them themselves and completing the repairs or avoiding the contract. So let's say I've done my due diligence and we've come to an agreement as to what you'll repair, and then the VA comes back in and says, in order for you to do the VA loan, this item has to be fixed. Let's say it's a screen on the window has to be replaced. If the seller says, no, we've already done due diligence and I'm not going to do that, then the buyer, because they can't get the loan unless it's done, the buyer can say, okay, I'll pay for it myself, or they can just void the contract and move on. So that's an important exception to the rule there.
Gary,
Right.
let me let you take a breath here. I know you'll fly through the rest of this and do a good job, but we wanted to post a question. If Kathleen could put up question number 10, it just talks about the timelines. Hopefully you have your calendar on your phone that you can follow along. If a contract is ratified on August the 3rd, 2020 at 4 p.m., what day and time will the 10-day due diligence period begin and end for the buyer unless extended? Remember, Gary went over in detail exactly what time a business day begins and what time it ends. So that should give you a big clue as to how to answer this question. And I hope we get 100% here. So just take a minute to do that. We'll give you a few minutes to count the days on your calendar. Kathleen, leave this up just a little while longer. And if you will show the results. So 71% of you got the answer correct. Remember, a business day will always begin at 8 a.m. So the answer's where it begins at 12 a.m. Any other time will not work. It has to begin at 8 a.m. and end at 7:59. So that should be a big clue for you. So hopefully that helps as you put together your timelines. Thanks, Gary.
All right.
I just want to say that one more time. A business day always starts at 8 a.m. and it always ends at 7:59 a.m. There's never a 5 p.m. There's never a midnight. There's never any other time. It's always 7:59 or 8 a.m.
All right, very good. So let's move on now, and we got about 30 minutes left. And so there's a few provisions I'd like to spend a little bit of time on in here. Other ones we kind of will be flying right through them. Number 11, condition of the property. This is very important, except for as-is contracts. If you're under paragraph 9, this is very, very important. Once you finish your negotiations, and I think, Becky, you and I did a video on this one, did we not, on paragraph 11?
Yes, 8 and 11.
Yeah, so Becky and I did a great video on paragraph 8 and 11 where we spent about 30 minutes going through all of the details in this provision here. Very important. CCRA has that one as well, so I advise you to watch that. But with the exception of as-is properties, once we finish negotiating repairs, the seller's got a duty to maintain the property in the same condition as it was once that was done. So if I'm selling my house to you and my water pump goes out on my well, guess what? I got to fix it unless you're buying my house as is. And I remember years ago when I sold my house, that's exactly what happened. My well went out, the pump went out on the well, $1,800 later, I had to pay for it even though the house was under contract. So you have a duty as a seller. So if air conditioner unit goes out, house starts leaking, whatever it is, the seller's got to fix anything that happens after the contract's been signed and the repair negotiations have been completed. They got to repair all that stuff. The reason that is the buyer has been promised a house in a certain condition, and if the air conditioner goes out, well, you aren't delivering the house in the same condition in which I agreed to buy it.
That also goes to keeping the lawn mowed and things like that, right, Gary?
Yes. And then we've got in here including lawn, shrubbery, ground, fixtures, things of that nature. So that's another one of those things that we put in there, kind of a feel good about making sure that the grass is cut. I will tell you, I handled a case out of Charlotte, or no, it was not Charlotte, it was out of Fort Mill. It was a multi-million-dollar house, contract signed. 60 days later, they come down here to close from somewhere up north. And the seller didn't cut the grass for 2 months in the middle of the summer. They didn't cut the bushes. They didn't pull the weeds. They didn't keep everything in the yard up. I mean, it went from looking like a multi-million-dollar house to look like this thing was in foreclosure. It was awful. And so to fix it, now, of course, the repair amount was ridiculously overly inflated, but a company came in and wanted like $20-something thousand to repair the yard, put the yard back in the condition. I thought it was ridiculous. It probably was several thousands of dollars. It wasn't 20 grand. They wanted bushes replaced. But my point being is, be careful with that. Make sure your client understands that the lawn, the shrubs, and all that need to be maintained. They don't get to just quit work, doing things at the house because they're under contract. All right. The other thing here, I've had cases on anything that would adversely affect the value and conditions are hidden by furniture, fixtures, window treatments. So if your client knows beneath the rug is a bad part of the flooring, I mean, it's all rotted out, whatever, that's hidden by furniture or hidden by carpets, that's something they're going to have to repair once it's revealed. And I had a case on that as well, where after the person moved out, there was a problem with the floor under the sofa that the seller knew about but had forgotten about. So it had to be repaired. So be careful on that. All right, paragraph 12 talks about property condition disclosure statement. We could do a good 2-hour class just on this in and of itself. You have two options here, A and B. Option A says that the property condition disclosure statement has been provided prior to contract acceptance. Section B says they agree that the seller will not complete nor provide the disclosure. You have 13 exceptions under the property condition disclosure statement. The fact you don't live in the house is not one of them. Investment properties is not one of them. The church owns it. A nonprofit owns it, are not exceptions. It's a landlord, not exception. This is a flipper, not an exception. An investor's not exception. None of that's exceptions. And everybody always tries to allege that's an exception. It's not. The 13 exceptions basically are limited to things such as federal government, state government, tax sales, foreclosures, and things like that, estate sales. That's about it. There's not a lot that the average homeowner that you deal with is accepted from it. Now, there's one exception, which is number 12, I think it is. If the parties agree there won't be a disclosure, then y'all can do that. So if I'm selling my house and say, I'm not giving a disclosure, you can either buy it or not buy it. As long as that's disclosed up front, parties can agree Gary's not providing a disclosure and the buyer consents to that. That is something allowed under the statute. But other than that, most of your exemptions that most people claim are not, in fact, exemptions. I've done a video on that. I think it's on my YouTube page. You just go to YouTube, type in Blair Cato. Lead-based paint, don't really need to talk about that other than to say if the house is built prior to 1978, the house may have lead-based paint. I will tell you that when the inspectors come to your office, one of the questions one of the things they always ask to see is a copy of your lead-based paint form. So just be sure that you're getting them signed as needed. Paragraph 14, home warranty coverage. So what this says here is the buyer and seller agreed there'll be a home warranty providing at least 12 months of coverage. Our prior rendition of this contract said would provide a 1-year policy or something like that. And so what some really sneaky sellers were doing is that they would have a 1-year coverage that only had 3 months of coverage left on it. And they were saying, well, this is a 1-year policy. It just has 3 months left. So we changed the language here to say it has to have at least 12 months of coverage. So that's something we had to fix. Buyer will or will not be providing at closing. It says whether or not you'll be providing it at closing. The warranty is going to be paid by either the buyer or the seller. Be sure you're checking all of these boxes, please. List the amount and who is provided by, what company. This is the number one thing that closers and paralegals will tell you that drives them crazy, is that this information is not filled out completely. All it will say is a warranty will be provided. Oftentimes it won't say who's paying for it. Oftentimes it won't give us the amount or the company, and then the agent won't return the phone call, and then they show up to closing and we're like, we need the warranty, and they're like, oh yeah, and then they call the warranty at the closing table. That causes delays for you getting funding. So please don't do that. Provide that information as soon as you can. Go ahead, call it in, send it to the closing attorney immediately so that it won't cause delays. If the price of the warranty is more than what's entered here, the buyer has to pay the difference. So be sure you're paying attention to these increases in prices. They don't go up very often, but when the prices go up, you need to make sure that you are getting your contract done properly. There's another reason right there why you want to get it called in early, because if today the price is $395 and you call it in and get it set up and send to the attorney, if the price goes up next week to $425, you've already got it in at $395 and your client's not paying that other $30. So be sure to get that done. All right. Property condition. These are the next part of the contract here. There's a lot of stuff about just disclosing things, and a lot of us try to keep the agent out of trouble. We're recommending that the buyer go out and have a copy of the plat reviewed, look at the restrictions and the covenants and the property condition disclosure and things of that nature. They'll look at the survey to make sure the boundary dimensions and everything's exactly what they thought it was, to measure square footage, to have get title opinions or title searches done, to get title insurance and things of that nature. That's all simply there to try to protect you. The buyer then is going to acknowledge whether or not there is a third party that has to approve the contract. That's very important. Back in late 2000s, this was an everyday occurrence where we had short sales that had to be approved. Not so much, so we moved this from the top of the contract here under paragraph 15A. 15B talks about whether or not you have sewer or water. Do your best to fill this in. I recognize this is a problem that oftentimes the buyer does not know the answer when it's being when an offer is being submitted. So sometimes it's being submitted blank. Make sure that it is being completed. Paragraph C, we've changed this a lot. This says, as far as a flood hazard area, that the sellers, to the seller's best of their knowledge, the property is or is not. The previous contract had them warranting that it was or was not under the special flood hazard area zoning. And our position was they don't know, because those zones get changed all the time, as we know from the 2015 flood we had. If the seller says it is not in a flood zone, says it is in a flood zone, buyer understands that we may have to purchase flood insurance. So that's letting them know up front. However, if the seller says it's not in a flood zone and it determined after the contract's accepted that it is in a flood zone in which the lender is requiring insurance, then the buyer has 3 business days after receipt of the notice from the lender to notify the seller they're going to terminate the contract. If they don't notify them within the 3-day period, then they're going to move forward. That's important, because if your client's already kind of on that line as to qualifying for the loan, and now all of a sudden their monthly payment's going up $100 because they have to have flood insurance, it may knock them out of qualifying for the loan. Under paragraph D and E, now it's talking about HOAs. We have 2 separate ones. One is a mandatory association fee. This is your annual fee. And then special assessment may be an assessment that is being levied to repair roads or make swimming pool repairs or things of that nature. It's important to understand with a special assessment, the timing of that is important as to who's responsible for paying for it. So if the special assessment is levied before closing, the seller's got to pay. If it's levied after closing, it's going to be the buyer's responsibility to pay. Now, you may get into a disclosure issue if the seller knew, because they were at the board meeting and they had been told that the assessment had been approved and would be issued September 1st, and they don't disclose to the buyer that on September 1st, this $10,000 assessment is going to come out. You may have a disclosure issue, but absent the seller knowing, it depends on when it's issued as to who's responsible for paying. So before closing, seller; after closing, buyer. Number 16, additional contingencies. We could do a class on this as well. Section 16A is the selling close contingency. Addendum is or is not attached. 16B, closing addendum contingency is attached, and other conditions. Now, we did I think Becky and I did this one as well, I think. Did we not, or was it with John?
It was the 3 of us, I believe.
Yeah, so Becky, John, and I did a great video in the CCRA archives that talks about all these addendums. And I think we spent a good 45 minutes going over them. In a quick 2 or 3 minute time frame we have here on this subject, a closed contingency, we'll talk about that one first. A closed contingency means that I am offering to buy your house contingent on me closing the sale of my house. My house is under contract and it is scheduled to close. That's a closing contingency. If I am under closing contingency, I am in, and you accept my contract, I am in primary position and I cannot be beaten. You can't bring a better offer in to beat me. And as long as my house closes, my contingency is satisfied, and then I buy your house. That's what we typically see a lot of the time. A selling closed contingency is different. A selling closed contingency says, I'm making an offer to buy your house. I have a house that has to sell and close, meaning that it's not even under contract. It's a prayer shifter. You're shifting your prayer from praying you sell your house to now you're praying that I sell my house. My house isn't under contract. And I got to get my house under contract and sell my contract in order to buy your house. So it's not really a wonderful contract. You can beat my contract with a better offer as long as that offer is not also a sell and close contingency. So if a close contingency offer is made after you've accepted my sell and close contingency, after you provide me proper notice, you may bump me out and a sell and close bump my sell and close contingency out and accept the close contingency, even if it's for less money. Very important to understand. I'm not going to go deeper into that. My suggestion is go watch that video on it. It tells you all you ever needed to know on that topic. We had a really good discussion. Paragraph 17, fixtures and personal properties. We did an excellent job defining what fixtures and equipments are. If people call me all the time and say, hey, are lamps or blinds fixtures? And my response is to read the contract. So read the contract. It tells you these things and others are. And just to hit some of the highlights, shrubbery is a fixture. Do not dig up plants. I've had people do that. Shutters and blinds are fixtures. Do not take down the blinds. Play sets. This is the one we get questions on all the time. We added this a couple of years ago. If it's a play set, it's a fixture, whether it's cemented to the ground or not. If you're not going to convey the play set, make sure that you're putting in there play set doesn't convey. All lawn irrigation systems, including equipment, pool and spa equipment, because you're going to convey the pool, you're not going to take all the equipment with it. The equipment stays with the pool. We also added TV wall mounts and brackets. So now that we're all mounting TVs on walls, the mounts and the brackets stay, the TV doesn't. We have not addressed speakers. So obviously the speakers that are cut into the ceiling, yes. The ones that are maybe attached to a bracket, I don't know. That's a question. If you want it, make sure you put it in the contract. You'll see that satellite dishes are here, seller-owned security systems, smoke detectors, central vacuums, landscape lighting, ceiling fans. Ceiling fans is big. We also added for mirrors. We got tired of the arguments on the bathroom mirrors. So any bathroom mirrors, including hanging mirrors, attached or hanging bathroom mirrors. So if your client doesn't want to include that bathroom mirror, they better write it in the contract that it does not convey or take it out before they sell the house. We've actually had to go as far as to add light bulbs. We had idiots that were removing all the light bulbs. We've had people that take the toilet paper holders. I mean, it's absolutely asinine, the stuff that people do. But this is a good laundry list of things that are fixtures. Two things that are not in there that we may have to address the next time we amend is Ring doorbells. Is it a fixture? Hell, I don't know. It's screwed in. Typically something affixed is a fixture, but the second part of a fixture ruling is, can it be easily removed without damage to the property? Well, certainly I can remove that little screw and there's not much damage to the property. So, if you have a Ring doorbell or Blink or one of those, again, if you're a buyer, write it in the contract. If you're a seller and it's not going to convey, write that it's not going to convey. I've gone both ways on. I don't know whether it is or not a fixture. I kind of go back and forth on my opinion on that. The other thing is the Nest thermostats. I think that's a fixture. I don't think it can be removed. But I've had people remove the Nest thermostats and put in the little cheap ones where you push the button or you push the little knob across. So again, put it in the contract if you want it. Paragraph 18 is a great provision section to write additional terms, to write seller financing terms and things of that nature. Paragraph 19, as we finish up here over the next few minutes, real estate taxes, very important you understand this. Taxes, and we argue, believe me, we have argued this for 12, 13 years. There is no good answer. There is no fix to the situation. As y'all know, in South Carolina, 4% if you live in the house as your primary residence, you're taxed 6% if you don't. That's could be a doubling or tripling of the tax bill. We understand that. We get it. Taxes, according to our contract, will be adjusted as of the date of closing, and it's going to be based on the most current tax bill. We put that language in there to give everybody certainty. As a real estate agent, all you got to do is go pull the last tax bill and you know what the tax proration is going to be. It's that simple. Now, we recognize that sometimes a seller will not be living in the house and be taxed at 6%, and a buyer will be buying the property and will be taxed at 4%. I get a little frustrated when I hear agents saying that the seller's getting screwed. The seller is not getting screwed because the seller is supposed to be paying 6% anyway. And all that's happening is the seller's trying to use the buyer's 4% to get money back. So quite frankly, what I think is happening is the seller's trying to take the benefit that the buyer's getting and trying to take it for their own self. So we understand that, but it is what it is. Now, we've had closing situations here the last couple of months where the contract, where we've had investors buying property where they're going to be taxed at 6%. The last tax bill was at 4%, even though the homeowner's not living in the property, and we know it's not, the tax bill is not going to come out right. And we've had situations where investors have only gotten low tax prorations where they needed bigger ones. We've seen that stuff happen. I mean, I've seen where sellers are giving low, or buyers aren't giving a very big proration, and we know the tax bill is going to be thousands of dollars. I mean, I had a seller irate about it. He knew the tax bill was going to be $6,000 and they prorated on 2. Sorry, nothing I can do about it. You as an agent, you can't have this modified to say that the parties agree that it will be taxed at the owner occupancy rate. If y'all want to do that, it's a negotiated term. If I'm a buyer, I would never agree to it, but buyers sometimes agree to it. Where we do not need you having this discussion is at the closing table. Because what I've had happen is we've prorated taxes at 6% because that's what the tax bill was, and somehow the agent comes in and raises Cain about it, and the seller's agent or the buyer's agent not understanding it say, yeah, that sounds reasonable, and so they agree to reprorate the taxes now at 4%. So instead of the seller giving a $4,000 tax credit to the buyer, they wind up giving them a $500 tax credit for the buyer. So now guess what? The buyer now needs to bring $3,500 more to closing, which now means the loan may have to go back to underwriting, which may mean it may not go through. So don't do this at the closing table. Do this at the time of the contract's written. All right. And if you're a buyer and they try to bring this to you at the closing table, all you need to do is say prorations are final. It says so right there. Be careful for lawyers. And there's a couple of lawyers who were doing this, and I hope they stop. That they decided to prorate on the last year's bill plus another 2% because taxes might go up. Not their prerogative. They don't have the right to do that. Do not let them do that. The contract says we're going to date it as we're going to adjust it as a date of closing, and we're going to use the most current tax bill. The reason taxes are final, we do not want the consumer calling you after closing saying taxes were prorated at $2,000, then the tax bill came out as $2,100. So the proration's wrong. I want my additional $8, because that's what happened before we put that provision in there. You would get called all day long, people wanting you to go get their $15 or $20 or their $100, and then you would call us, and then everybody expects the lawyer to go file a lawsuit over $50. So prorations are final. There is no change.
Hey, Gary, one thing about that too is there's a lot of attorneys that practice in different parts of the state, and there's different contracts that are used. And so attorneys by default will have a reproration document they try to get people to sign at closing,
Yep.
which would override the contract. You as an agent can look at that and make sure that your clients are not signing a reproration document because they've agreed to a contract already. That changes
Right.
the contract. Attorneys don't have the right to
The attorney has no authority to change the terms of the contract unilaterally. So do not let them do it. Matt's exactly right on that. Great point. Paragraph 20 talks about what happens if the house catches fire and how to terminate it. I won't really go over that. Default, basically, if a party defaults, the other party may seek legal remedies available by law. Okay? And they are entitled to get attorney fees and court costs if they win. Now, I've told y'all before, and I'll say it again, the reality of it is, in order to sue somebody in real estate, you're going to hire a lawyer. It's going to cost you $300 an hour. Lawyers don't do anything in an hour. So to sue somebody in real estate, you're going to cost you $5,000, $10,000. Most of the time, your damages aren't going to get there. Very rarely, if ever, do you see somebody being sued under a contract these days, which sucks because I think a lot of consumers understand that, and they understand they're just going to walk. Okay, so just you need to understand going into this that while your client has all the remedies available under law, it's just the reality of it is it's so expensive to file lawsuits that oftentimes it's not worth the hassle. Now, with that being said, I did have a builder one time recently. He sold a house to somebody. They wanted pink carpet, pink paint. They wanted pink bathtubs. They wanted pink toilets. So it looked like somebody threw up Pepto-Bismol throughout this whole house, and then she just walked. My guy sued her, and he was able to get a lot of money out of her because he was going to have to gut the bathrooms and the kitchens and rip off of the carpet and repaint the house because nobody was going to buy it. And he held her in default and sued her, and I think we got about 40 or 50 grand out of her. So it does happen. It's just rare. Mediation, love mediation. If there's any issues in the contract, the parts can submit themselves to mediation through the association. I have started doing mediation cases for the association. I've got 2 coming up this month. I love it. It's a great avenue for the parties to get together and try to resolve their disputes. So big fan of mediation. So if there becomes a dispute where parties can't resolve it, tell them to reach out to the association, talk to Kim, talk to Taylor, and we can put together a mediation and try to get it resolved that way. We had one a couple months ago, post-closing, damage to the roof, and it was a pretty significant case, and we were able to get that one resolved. So it does work. The next part, legalese, this is a binding contract. Hopefully everybody understands that. Non-residence taxes, what we're talking about under paragraph 24 is nothing more than if your client doesn't live in the state of South Carolina, we may have to withhold capital gains taxes. The most common exception for that is if they meet the qualifications of primary residence, they lived in the house 2 of the last 5 years as their primary residence, then they typically would not have to do that. Or if they had no gain, then we wouldn't have to withhold money. But this is a question for the lawyer. You need to let the client, you need to let the lawyer know who's closing it if your seller does not live in the state of South Carolina. Expiration, this is the time the offer is withdrawn. This has been completely ignored recently. People submit this with a drop dead date and time. Some sellers aren't even looking at it at that time and responding later. So you need to try to enforce your expiration offer. Time is of the essence. It's basically a legal term. If there's a time frame in here, it means the time frames do matter. And when the court looks at those, they are supposed to look at those time frames as significant. All right, notice delivery. It talks about the different ways that we can deliver property, or you can deliver notices. Survival, if anything under the contract is deemed illegal or improper, the rest of the contract does survive. The last couple of parts here.
Harry, quick question. I know you're rushing through this. Someone asked me, is a text message a viable means of communication? It's not listed in paragraph 27.
We don't recommend it. There's some legislation, some state law out there about electronic means. It's just dangerous to accept it. I mean, it is evidence you could present. Here's the text. I do know that when I handle grievances, and that's one of the things I do for agents, I represent them when you have a grievance filed against you. I've been over there over 50 times, that the commission will accept text messages. So one of our defenses, we provide copies of text messages and say, here they are, and they will actually look at those. So those are good. Under notice and delivery, it's arguable right now. I think under our law, I think it probably would be allowed, even though it says delivery message includes courier service, U.S. mail, facsimile, and email transmission. It's up to the judge as to whether they're going to accept the text message. I think it's arguably they would at this point, because it's become such a part of our everyday life. So I do believe they would. Just be careful. Under 29, we've already talked about a business date. We're going to talk about successful negotiation of this offer in just a minute. So we'll go through that in a minute. A very important provision. See here in the contract, closing is defined as the date and time the attorney disperses the funds. Signing the documents is not a closing. It's dispersing the funds. And as y'all know, unfortunately right now, particularly if you're using certain credit unions that are related to certain military organizations, funding may take hours. Okay, so it's not closed until it funds. All right, settlement statement. We can get the settlement statement to the parties. Megan's Law, do not make a list of people who violated Megan's Law and put that on your website. Don't do that. I've had an agent do that before. Just tell the client where they can find the sex offender list and tell them to search it on their own. Do not give them names. Last 2 paragraphs are basically CYA. They basically say, you haven't provided any legal advice. You're telling the client to go talk to an attorney. Right here, you're not an attorney. You're not a tax advisor. You're not a lender. You're not a surveyor. You're not a structural engineer. You're not a mold expert until you open your mouth and try to become one. So understand, you said here that you're not those things, but when you start giving legal advice, you start giving tax advice, you start giving value advice or structural advice, now you've opened yourself up to lawsuits on those matters. Cannot stress that enough. Stay in your lane. Do not get into the lawyer's lane. I don't get into your lane. Don't get into my lane. I don't get into the lender's lane. When people ask me stuff all the time about taxes, whether it's deductible or not, I don't tell them anything. I don't know. I don't do tax work. Stay in your lane. You won't get sued. A better chance of not getting sued for that. And then lastly, the disclaimer here, we talk about physical condition of the property, title. We don't know anything about it. It's not your responsibility. Now, the last thing we need to talk about on the contract, very important section. When do we have a ratified contract? Under the law, a contract has to be signed, sealed, and delivered. There was a song years ago, signed, sealed, and delivered. What we're talking about is the contract has to be signed by the appropriate person. Again, we talked about that earlier. Make sure the right person, the right seller is signing the property. Make sure all sellers are signing the contract, rather. Not just one person. All sellers are signing the contract. All people of record, title of record. Make sure that if it's a company, the person with the authority is signing the contract. If it's a church, we need to make sure it's the right person with authority signing for the church. So that's first thing, signature. Second thing, sealed. As you will see, we wrote the letters LS. In case you've ever wondered what LS means, that's legal seal. It's a legal doctrine about how long the statute of limitations lasts. Don't need to get into it, but signed and now sealed. So now we're talking about delivery. The contract has to be signed and sealed, but it has to be delivered back to the person making the offer. I make an offer to Matt. Matt takes my contract and signs it. We do not have a contract until Matt sends the contract back to me. Because until Matt sends the contract to me, I can rescind or revoke my offer. So if he signs it and goes to the beach, what do I got? Nothing. I can revoke it. Now, I make an offer to Matt. He counteroffers it and sends it to me. I sign it. He signed it. We don't have a contract until I give it back to him because he was the last person making the offer. So this section right here at the bottom is then filled out by the person who receives it back, the receiver. Think football terms. The receiver is the one who fills that out, not the quarterback, not the person sending it. It's the person who receives it. Once that person receives it, then they fill the information out. If that's not the case, it could shortchange due diligence. I made an offer to Matt. He signed it today. He goes to the beach. He sends me back, dates it, sends it back to me next week on the 19th. If he has filled that date out on the 12th, I don't even know I have a contract until the 19th. He has now cut into my due diligence period, and that's wrong. So I need to change it and send it back to him and say, Matt, I'm the one who fills this out because you had to send it back to me. It's corrected now. Question always I get, always get this question. If it's not filled out, does that mean we don't have a contract? No, this has absolutely nothing to do with whether or not you have a contract. This is just providing information so that we know when the contract was ratified. Once the contract is signed, sealed, and delivered, it's a contract. It's a ratified contract. This here is just notifying the parties as to when our timeframes have begun and when they end. All right. That's that. We are done. I appreciate everybody's attendance today. I hope everybody was able to get something out of it and provide questions and answers to our great panel. I'll turn it over to John in a minute. If y'all have any questions, please do not hesitate to reach out to me. My email is, let me get rid of my stop share. My email is right here. So if you have questions, I love getting your questions because it does help us as a committee look at areas that we may need to change. So please continue to send us all the questions that you can. CCRA, as we mentioned, has 4 or 5 great videos. We strongly recommend you watch those. You can go to Blair Cato on our YouTube and watch the series that I did with Matt and some other brokers and cars, talking contracts. You'll find a lot of contract information there, as well as on our legal tips we send out from Blair Cato. We send out a lot of contract stuff as well. So thank you very much. I will now turn it over to John to finish us up, and we appreciate everybody. Thank you so much.
Thank you, Gary. Appreciate you and you doing that. So we're going to stay